assisting this afternoon in relation to the evidence that's about to be given in relation to clean energy. The evidence that's to be given this afternoon is in the form of a presentation which will take approximately 20 minutes and we will have some time for questions after the presentation. Then after that, we will hear evidence from members of a panel, 2 of whom are present in the hearing room and 2 are on the screen, coming remotely from various locations, including Ms. Nolan from Rotterdam. Commissioners, I will deal with those that are making the presentation first, and they are on behalf of the Barngarla Determination Aboriginal Corporation, Sonja Dare and Jason Bilney, and they are on the screen. You can see on the top left panel, and Nick Llewellyn-Jones, their lawyer, is with them. Is Jason there, Nick?
I think he's on a separate panel. I think
there. Yes, I can see him.
Yeah.
Okay. Now, I will firstly swear these witnesses in, and I'll start with Jason. Jason, could you tell the commissioners your full name, please? No. He's trying to, I think. Can you unmute, Jason? Can you, if you can do that while I'm speaking to Sonja. Sonja, can you tell the commissioners your full name, please?
Sonja Lee Dare.
And you're here on behalf of the Barngarla Determination Aboriginal Corporation?
That's correct.
And the evidence that you will give to this commission will be the truth?
Yes.
Thank you. Jason, can you hear me?
Yep, I can hear you.
Can you tell the commissioners, please, your full name?
Jason James William Bilney.
And you're appearing at the commission on behalf of the Barngarla Determination Aboriginal Corporation?
Yes.
And the evidence that you will give to this commission will be the truth?
Yes.
Thank you. I'll now turn to their legal advisor, Mr. Nick Llewellyn-Jones. Nick, could you tell the commission your full name, please?
Yes, Nicholas Llewellyn-Jones.
And your firm is Norman Waterhouse?
That's right.
And you're the lawyer for the Barngarla Determination Aboriginal Corporation?
Yes, I run the No-Toll Resources team and we collectively represent the Barngarla Determination Aboriginal Corporation.
Thank you. And the evidence that you will give to the commission today will be the truth?
Yes, absolutely.
Thank you. Now, I'll turn to our other witnesses and deal with those in the hearing room first, commissioners. Mr. Paul Paton, can you, we know that you've been here just last week and you're returning, but could you tell the commissioners your full name again?
My name is Paul William Paton.
Sorry, Paul. And could you tell the commission which organisation you're here representing today?
I'm the CEO of the Federation of Victorian Traditional Owner Corporations.
Thank you. And the evidence that you're about to give today will be the truth?
Yes, it is.
Okay. Thank you. And Mr. Kneebone, could you tell the commissioners your full name, please?
Jonathan Kneebone.
And you're here representing which organisation?
First Nations Clean Energy Network.
And the evidence you give to this commission will be the truth?
Yes.
Thank you. Now, returning back to the screen and following on from Mr. Kneebone, Karina Nolan, could you tell the commission your full name, please?
Karina Nolan.
And you're here on behalf of the First Nations Clean Energy Network as well?
I am.
And the evidence that you will give to this commission will be the truth?
Yes.
And finally, but not least, Rebecca Halliday. Could you tell the Commission your full name, please?
Yes, Rebecca Halliday,
And the organisation you're representing today?
GIRA Consultancy.
Thank you. And the evidence that you will give to this Commission today will be the truth?
Yes.
Thank you. Now, Commissioners, the format that we're proposing for today's evidence is to have a presentation from the Barngarla Determination Aboriginal Corporation group in relation to certain clean energy deals that they've been involved in recent times. And after that presentation is completed, there will be an opportunity for questions from Commissioners. I might invite the Barngarla representatives to deliver their presentation.
Yes, thank you. Do you have that on the screen? Is that something that can be shown or walked through?
Yes, I understand that we'll have it in here it is. Thank you.
Right.
So can you see the presentation on the screen, Mr. Llewellyn-Jones?
I can. I can't change the slides though. So
Yes.
maybe when we've got through a slide, we'll just say the word slide and whoever's coordinating it can move to the next slide.
Thank you very much.
Okay. Well, we can probably move to the next slide and start the presentation.
Okay.
And we've gone through the introduction, so maybe we can move to the next slide. Did you want to talk about the history of your native title fight, or Jason, did you want to talk about the history of your native title fight briefly?
I suppose I'll start it off and then Jonas can jump in at any time. So we're one of two native title groups in South Australia that's been through federal court. I've been through court, and only one of two groups that's won a full determination, not a consent determination. So we fought long and hard as a community, as an organisation, to win a native title after 21 years. And bear in mind, it took us another 2 years to win Port Augusta. So it's taken us 25 years of fighting for our rights to be recognised as traditional owners of Eyre Peninsula. And, and then since coming out of that, people were knocking on their door. And then after coming out of native title, normally you set up structure 1, but we've sort of jumped straight into up to 2, 3, and then up to 4, and basically doing a lot of negotiations with companies. So I'll let Jonas take over now if she wants to add anything.
Yeah, sorry, Jonas is my nickname, just for everyone. Jason was absolutely correct. It did take us a long time to win our determination. And the first one that we won was about 21 years. And what is interesting about that one is we were advised by our lawyers, by Nick, not to have a whole of Illua claim over our determination. So that's a whole of Indigenous land use agreement over the determination with the South Australian government. So when mining companies or multinational companies or energy companies want to start a business on Barngarla country, there's not a whole of Illua claim over it. So they actually have to negotiate with us, the traditional owners. So that was really fantastic advice that we were given by Nolan Waterhouse, by Nick, which has enabled us to, I think we've done nearly half of the Illuas in Australia now.
You've done about 85% of all Illuas in South Australia, and you've in South Australia, you've done maybe a third of you can't negotiate about a third of all Illuas in Australia. I might just do two things if I could very quickly. Firstly, I might just ask you to get to the air conditioning. So I've just got someone with me with the air conditioning behind us. It's become very loud. The second thing is just to give some context on that, because the situation is different in each state. In South Australia, what often happens is that there's a consent determination process for native title, and as part of that consent determination process, the state government will often try to create Indigenous land use agreements which apply over all of the residual native title land in the determination, and create what they call a streamlined process in order to approve future acts. That often creates situations where they can issue leases or easements without further negotiations. That's not always the case in other states. It is a case in South Australia. This is not what's proposed. So the advice that Sonja is referring to is the fact that when Barngarla won their native title in a trial, they had no reason to engage in a watering down of that right to negotiate process for a settlement because they'd already won their native title at trial. It might have been a different situation had the state sought to settle their native title to a consent determination and asked for an IDUA, which I suppose weakened some of the right to negotiate provisions. But because the Barngarla had won a trial, they were in a position where they didn't have to agree to some kind of compromise like that. And so as a consequence, we advised them that they shouldn't agree to any IDUA which weakened their native title negotiation process rights, and they didn't. So that's the context of that. It should be noted, though, that might be different in different states. It may well be the fact that Victoria would not require such provisions in their determination settlement IDUAs. We don't have the context of that. It's a specific South Australian issue. Maybe if we move to the next slide, do you want anything else to add on that?
No.
Do you want to talk about the area quickly, or do we move on?
So in our native title determination, we have the three main rural towns of South Australia. So down the bottom of the peninsula, we've got Port Lincoln, and up towards the top, we've got Whyalla and then Port Augusta.
And bear in mind, they just said it's about the three biggest regional towns, but bear in mind a lot of our projects that are happening in the top end of our country, where you get more sunlight, more daylight in that Port Augusta, Whyalla across the top end, and so it's like we've known for a while, but all roads lead to Barngarla country, especially within that top end. It's on the cusp of decarbonisation.
All right, we might move to the next slide, and I might quickly talk on this one. So even without a determination, IDUA weakening the Barngarla's, creating a framework for negotiations which might remove the Barngarla's rights in those negotiations. And I can give examples of that if that's of any interest to anybody, but we'll move on and just accept that for now. Even without that, there's still a lot of extinguishment within the Barngarla determination area. You can see here on this map that the areas in the orange are extinguished areas, and then the green is where the native title exists. There are little bits of native title throughout that orange. I should be clear, it's not homogenous. There's a sort of heterogeneity to it. But it's obviously the further south you go in the determination area, the bigger levels of extinguishment you get. I know this is relevant to point out to this commission because, of course, in Victoria, you have such an extensive level of extinguishment. So it's probably useful just to show that when dealing with Barngarla, or using Barngarla as evidence potentially for the exercise that you're undertaking, that this is not a group which has native title throughout the entirety of its determination area. It struggles with the injustices, I suppose, of the extinguishment law that exists throughout Australia, where obviously you can win a determination and then have a whole bunch of tenure, which removes your native title framework. So that's that map. Do you guys want to talk to that at all? Or? Then
I suppose you'll have it on the next map where the pink snake runs. Even though extinguished, the more south you get, the more extinguished land, but that strip runs right along the coastline, right from the top of our determination down to the bottom, which gives us more negotiations like we've done with the three ports.
Yeah, that's on the next slide, in fact. So if we move to the next slide. So there's some context, and we're kind of probably coming around this backwards, and we'll get possibly to a more this will all come together at the end in this presentation if people can bear with us. But one of the issues when Barngarla won their native title was that they came and they wanted to have proper resources to negotiate with companies because they were very concerned about the terms of companies providing. The effect of that was that they took a very strong position on their negotiation approach. One of the things that we discovered in all of this was that there's often going to be projects which are built on freehold land, but where they still cover native title through some critical infrastructure corridor. The classic example for Barngarla were the ports, where a lot of port projects needed to get access to the sea. Barngarla was still able to negotiate large shareholdings in the ports and throughput rates because there was no way to access the sea without going through a 5-metre line of native title. So the reason why we raised this early is, I think, to try and show some comparison to the Victorian situation. It's not a core part of the presentation. We want to talk about the renewable energy industry and our experience with business, and the Barngarla want to talk about their experience with dealing with these companies and how they behave and the good and the bad. But I think it's useful to show that there has been some negotiations which have been done entirely on projects, but there's only been 1% of native title of the project footprint has been affected. There's been critical land connecting to a substation or to a coastal area. So we grapple with these issues, Barngarla grapple with these issues. Makes it very difficult because you could have one project which provides very good benefits, but another project which is almost identical next door, which provides very bad benefits. But the Barngarla's position has been to try and be strong negotiators for all of these projects, and we're sort of trying to give some context of the challenges. Did you want to add anything to that, Jason? Because you have dealt with that in terms of the struggles of dealing with companies. I mean, Sonja has too. I should prioritise, but I know that it's been an issue that we've all had to grapple with. Did either of you want to add anything?
No, just with the ports, just like anything being First Nations Creek, you tend to be labelled from the start. You know, when you basically, you know, they'll bring in more lawyers or advisors, and you know, to belittle you, and then that's why we've gone down the angle of being entitled to the same amount of lawyers and advisors, but also making the proponents pay for it. And you know, you sit there at the table and negotiate, and basically you basically negotiate, and then lock them into an agreement, and then basically from there, whatever money. So it was some of the proponents were hard to deal with at the start, but over time, a lot of the proponents have come very aware how to deal with BDAC, and it's been. But you still get some that'll still come along and try and lowball you. But with those ports is really a good example where basically one of them was a renegotiation, and that was being hard at the start, but then basically the CEO of T-Ports basically came to the table and really wanted to sort it out, and basically sorted it out, and that's where we sort of got, you know, like free output for a grain port, you know, whatever grain goes out from a low year to a drought year to a high year, and that's helped us with our other deal with the other port down, and also down in Port Spencer. So basically use the same model to negotiate. So we, you know, have examples of the ports to basically example for another port where one is a full grain, another one is a commodity port, and then the third one was another commodity port to renegotiate that as well. So no, it's you learn to deal with companies, but some of them might sort of outnumber you, but then what don't make you weaker sort of makes you stronger to be empowered to take it to the next level and to negotiate and push that envelope.
So are you happy, Sonja, if we move? Yeah. So we might skip ahead a few slides if that's okay, because the next slide is just a map showing the native title breakdown, and where blue is native title and red is extinguished land, just to show that there are similarities with problems in Victoria. And the next one is just a list of examples of projects Barngarla have successfully negotiated. We can move ahead with that, and maybe the presentation can be submitted. But what I would like to do is actually go to the next slide and actually move forward to this slide. You take and the table would be good. No, the table is good, thank you. The next slide would be good. Thank you. So I think this shows where the fundamental problem is. Are you happy for me to talk to this one first? Yep. Jason, are you happy for me to talk to this one first?
Yep.
Yeah. Okay. So we've done a number of negotiations with Barngarla, who have got a very sophisticated board of directors, and we're a large law firm in Adelaide. By Adelaide standards, we're one of the top 5 law firms by size here. And we've finalised around 10 large project agreements, some in renewable energy, a lot in renewable energy, in fact, and we'll get to those because that's obviously the topic of today's evidence, but also some in infrastructure, some in desalination, etc. Looking at those 10 or so negotiations, it might be, and the reason why I can't be totally precise on that is that some of them are in MOA stages, some of them are finalised. There's a note in this presentation which explains that. But taking those negotiations as a whole, whether 8 or 10, we've discovered that effectively in most instances companies will come along and their first offer will be about 1/10 of what we'll finally settle on. Or if there's multiple companies which are proposing projects on overlapping land, so you might have multiple proponents wanting to build something on the same bit of native title land, then if there's multiple bids sort of put forward, there'll often be a divergence in price between 1/10 to 10 times. Now, obviously, there's other factors which are important in these negotiations. Heritage protection is paramount. I don't want to talk to that. It's not my role to do so. I'll leave Jason and Sonja to talk about that, cultural respect and so forth. But what there is, which I will talk to, is evidence of pretty significant price divergence, compensation divergence, and probably what could ultimately be argued as lowballing by industry. Now, some of that will be, in fairness, legitimate debate about price in circumstances where it's really hard to assess price. We've changed the views of projects and so forth. There's some really complicated economics with that. That's okay. Like some of that's quite genuine. Some of it's just a lack of awareness by industry about how to deal with native title. So some of it's innocent. Some of it is probably more genuine lowballing. But in any event, what there is not one price which comes forward with these projects. To a T, almost every single one has come in with an offer which has been 1/5 or 1/10. The worst one was the one where we renegotiated. Jason just referred to it, not the port he referred to, although that one was a renegotiation which went up dramatically as well. But there was one renegotiation in Vanilla where it went up from around $50,000 a year to $1.5 million a year in benefit, which is a 3,000% increase in terms of price. So the main thing that we've discovered, I think, in dealing with this work for Barngarla that they've discovered is that there's a lot of companies which talk the talk. There's a lot of engagement and trying to be relationship building, but actually when it comes to getting an economic stake in the project at a reasonable share, there's a lot of work done to prevent that from happening. And groups need to be very prepared to be able to say no to projects or to stand up to negotiations in order to get a proper stake. Most companies come in and offer about 0.5% of the project value, not 5%, 0.5%. And after quite difficult negotiations, they can get up to about 5%. In some instances, much more. There's one project we'll talk to you about, which is very different. But the reality is that companies come in at a very low range. And that's not to blame the companies. Part of that is the fact that there's a very limited amount of market data. ILUAs are confidential. Companies don't know what other companies are paying. Aboriginal groups don't know what other companies are paying. It's not any time that native title is enlivened in a legal sense is when there's probably going to be a property development unless it's a past act compensation claim. And so therefore you've got difficulties about how do you value land. You have two bits of pastoral land. They might both be worth $1 million each. One might be 8 kilometres away from a substation. One might be right next to a substation. If someone's building a solar farm on that land, then, and this is all approximate, of course, to be clear, this is an approximate back of the envelope calculation. But the land which is next to a substation is likely to be $8 million more valuable than the land 8 kilometres away, with it costs $1 million a kilometre to build a power line. So you've got these issues where the project changes the value of the land. But in any event, what we've discovered is that there's a significant level of divergence in price depending on the bargaining approach that the groups take. Sonja or Jason, do you want to?
They're all at the lower end as well.
Yeah. Did you want to? Sorry, that was my little legal take on it, but I'm really conscious of not wanting to take away from the bungalows, the bungalows experience of this because I've not.
I'll jump in there, Nick. It's like a what they call the Coltana estate, where you get companies that'll come in and then sort of really lowball you. So just with the EPS land was about 750. Was 750 hectares, and the other land was about equal to the same. And a company come along, and they offered us probably was around about 130, 150 for both those parcels of land. And they also had Aboriginal people being the face of their company to try and build that relationship. And we said no, and we went through a competitive bid. We have the right as native title groups to put it to bid with other companies, and that was the lowest of the lowest. And basically, we got, like Nick said, we got tenfold just with one piece of that land and still following on for the second piece of land. And so some companies will, come across lowball you, but then some companies will get other Aboriginal people to try and push their agenda to actually get that land. And then we've lost that as native title groups. It's about us as native title groups taking real share ownership, let alone taking real term income of those projects. And that project was that sort of was a big eye opener for us, where the other companies that were coming along, and some were just lowball, what some were meeting in some places and not with others, and then some of them we basically had to educate them and re-school them that we're not going to go with this, and we want this is what it's actually worth, and this is we're entitled to X amount, and then basically with that project and another project which was built on non-compensable land. Basically engaged with and we're the only native title group that's got an electrical engineer, so we know the constraints of the power lines of solar and wind farms. So we've got that expertise, and that sort of helped us to negotiate other wind and solar projects which are coming along at the moment. Let alone dealing with big companies which are basically governed but not government, being Electronet, where we wasted 3 years of our time basically trying to negotiate a whole easement. And in the end, they didn't have right lawyers. And so there's lawyers, to understand native title, which makes it easy for our lawyers that do understand native title. And basically, within 12 months, we sort of had that project wrapped up to build the 260k worth of power line as well. But they lowballed us, and as in a compensation. It wasn't about the money; it was about real time. But also there was that many sites which are done back in the old days, probably back in the 90s, and so it was going through and getting that all documented and changing it to relevant male, female sites, but then also having a multi-million-dollar, monitoring program, which was, only meant to last for 9 months. It ended up lasting for 3 years, and it allowed, I didn't permit them to demolish the old power line where it was never part of the agreement. So, it was a 3-year process of that, which was only meant to last 9 months, but it was about having 90 members of our as in BDAC being out there, old and young, monitoring on a 3-week roster, 36 people on a given 3-week roster, just basically going along while they did any ground disturbance, any drilling, any works that happened within that easement. We basically had monitors out there. So, it's basically thinking the bigger picture, but also negotiating, but also having the right, having the right lawyers and advisors. That's the best thing a native title group could have.
Jason, it's Tony. Can I ask you to just, in the interest of time, to just tell the commissioners about the two projects involving renewable energy that BDAC has received Premier's Energy Awards for?
The two projects where I just talked about was the EPS project. So even though we negotiated that project, and that was worth X amount, when the government changed, basically we become landlords. So we become 100% landlord, rented it back to the company, it tenfolded, and we got an energy award for the EPS project, which is part of EPS and AMP. And then we also got an energy project for the biggest monitoring program on the 260k easement from Coltana in Wyler down to Port Lincoln.
Can we move to slide 17? If we move to slide 17, that might be the right place to pick it up for Jason's presentation to that question.
Thank you. Slide 17, please.
Thank you. Sorry, Jason, I just wanted to get the slide up for you.
Is that the slide there? Is that slide 17?
Yeah, that's 17. And then the next one, slide 18, is the EPS project, and then slide 19 is the ElecMed project. They're the two award-winning projects.
If we just stop on the EPS project, can you just explain to the commissioners about how it is that BDAC negotiated equity in the project company?
Oh, I'm happy to answer that. Yeah. Jason, do you want me to do that? Is that okay?
I think
we've lost Jason.
Yeah.
The connection might have disappeared. Are you happy for me to answer
yes,
that?
thank you.
All right. So that project was a project where there were multiple companies seeking to build a project on that land, and ultimately, as a result of that, the Barngarla were in a position to get a fair proposal from those companies, which included, in this instance, a mechanism for the land to be handed back to Barngarla in fee simple and an equity stake in this. It's actually a very topical issue because one of the issues that policymakers try to do is they try to select who the Aboriginal parties will deal with and create effectively a monopoly or monopsony power on a proponent. This is what happens in the mining industry. Someone gets a mining tenement, and it's only after that happens, or they like a claim, it's only after that happens that the Aboriginal parties get a negotiation process. In this instance, the Barngarla were very fortunate because they were able to actually negotiate with multiple companies who are all competing for access to the same land, effectively put it through a kind of an open tender kind of process. So as a result of that, and there's a long history to that, but I'll streamline it. As a result of that, the companies put forward much better proposals than they would have done had they not been competing against each other. So the Barngarla were able to leverage that internal competition between the companies. Now, it turns out that the company which the Barngarla ended up going with was by and large also very good. I mean, I should be clear, EPS particularly has a very strong history of good engagement. They've been a good company to deal with. But in fact, there's no surprise that there's a correlation between the best commercial deal Barngarla got with an equity stake and land being handed back, and a situation where that was a project where there was competition between corporate proponents to gain access to that land. The reality is that for Aboriginal groups, being able to ensure that companies can put forward honest proposals when there's microeconomic competition between them, you're going to end up with a much better solution than when a company has a monopoly kind of negotiation. Right. So that's how that came about, if that helps. Sorry, Jason, the question was to you. And
No, you're right. You summed it all up.
Yeah.
Do you want to add anything?
No, you summed it all. You summed it all up. Basically, going through that process of getting that land and change of government, and then then basically becoming the landlord with the new government, and then also becoming 100%, and then giving a native title up, and the government giving their 50% stakes and becoming the full landlord of that project.
There is one extra point we should make on this because it might be useful to the Commission. The model for EPS and the BDAC project for EPS is a model which should be applied more broadly, because it's actually the model which allows Aboriginal groups to gain better benefits without really increasing costs to industry. What happened here was there was native title land. The government had a rights over it and the Barngarla had rights over it. And unless both groups agreed to what happened to it, it was sort of 50-50 in terms of property interest. So there had to be sort of an alignment. Rather than the government trying to extract 50% of the rental payment or whatever, it agreed to transfer the land over to Barngarla in fee simple. Now, that means the company rents the land from Barngarla. I talked about multiple companies competing, and that's how the shareholding happened. But actually, the other level to that project is the fact that this is a very good way of First Nation groups getting access to benefits, because the reality is the company has to rent the land from someone. If the Victorian government, for example, hypothetically, has land that could be handed back to First Nations groups to develop projects like this, where they become the landlords and their rights as landlords and agreement for leases and so forth are done as part of the land transfer, then this is actually a very effective mechanism where effectively land which might not otherwise be able to be used, especially in the case of native title land, where you need both parties to agree, and that agreement might be hard to reach, where that land can actually be unlocked to make projects more efficient, and where the First Nation groups can benefit. So in this case, just to finish that point off, what we had was land, in fact, which required both the state and the Barngarla to agree. Reaching agreement was very difficult. Therefore, this very productive land, the Barngarla, was culturally appropriate to be used for a project, was being locked down and unable to be used. And in fact, the process of the state getting out of the way and removing its interests and going through a process with Vanillua to transfer the land to Barngarla in fee simple, so that the Barngarla became the sole owners of the land. Not only did that mean that a project could be built on it, but it meant that the totality of the benefits could be provided to the First Nations group. So it's actually a very neat proposal. The land became productive from a renewable energy perspective, whereas it wasn't beforehand. The First Nation groups got the benefit. So it's actually a very useful model potentially for other land banks around Victoria even.
And following on from that, and then Nick, it's like taking, say, 20%, 25% of the overall income per year, but also applying that to share ownership if they choose to take full equity and take share ownership in that project.
I agree. There is one final point. I know we're out of time, so we'll be very quick. But it's topical about the issue of competition between companies, because we've got issues in South Australia at the moment with new legislation where the government is trying to create a situation where you can select who the Barngarla deal with for renewable energy projects through a preliminary process of basically selecting a company before it issues a licence. Now, leaving aside the fact that that means a lot of projects may not be constructed, it actually significantly damages the Barngarla's capacity to negotiate effectively with industry. But it's been couched as a come and talk to the native title holders first model. So it's being put forward as something which is benevolent. Actually, from our experience of EPS, it's not.
We specifically said at the renewable energy workshops, we didn't want that to occur. We didn't want the government telling us who we could do negotiations with, and they went ahead and put it in the new legislation.
Thank you, Jason and Sonja and Nick. We are subject to some time limits. I might ask if any of the commissioners have particular questions they want to ask before we move on to the next panelists. Are there any questions that the commissioners would like to ask at this point? No. Okay, thank you. I just might turn to Karina Nolan and Jonathan Kneebone from the Clean Energy First Nations Clean Energy Network. Can you just briefly describe your role, the role of the First Nations Clean Energy Network?
Sure. Hello. Thanks everyone for having us. So we set up the network in 2021, and really it's got over 600 First Nations members now and thousands of supporters. But the main aim was really to bring our communities and First Nations voices into the clean energy revolution. It was very clear to us, talking with our Canadian counterparts, that we're a couple of decades behind, and I'm happy to provide some examples of some of the work that's been going on in Canada. But it was really obvious to us that projects, and I think the example that Nick and Jason and Sonja have just talked about has been really incredible, but a couple of years ago we weren't even really there. So we haven't been at the table designing the large-scale projects. Lots of our communities, I think, as we all know, including in Victoria, are experiencing the impacts of climate change, which means lots of our mob aren't able to stay on country. We've got thousands and thousands of households across the nation still living on diesel, on dirty power. So it was very clear that what we needed was a collective platform for us to come together to advocate both at a federal level, but also jurisdictionally to kind of deal with some of the policy barriers, to lift the aspirations of our community, but also to shift, I think, the thinking that industry had when it came to working with us. And we all know what there's been a long experience of industry doing to us, not with us. So there's a range of areas I can get into, but that's kind of in a nutshell been looking at the energy access issue, First Nations capacity, and the potential to have ownership and equity in projects, but also this issue of what does genuine engagement and consent look like.
And is it possible to describe in summary form the position nationally with respect to First Peoples' participation in the renewable energy industry?
Yeah, look, I think, again, it's very mixed. There's no one experience. And as I said, we've got communities who are living off-grid. We've got communities who aren't connected to the national electricity market. So people are having very different experiences. We were talking to communities who said to us the first time they'd heard about a large-scale development proposed on their country was a notice at the local service station. Completely unacceptable engagement if we think about the principles of free, prior and informed consent. Again, those issues around people in rentals where there's no scope to actually have rooftop solar, people aren't able to get the rebates. There's complications around who owns the asset. We've done a lot of work, actually, particularly in the Northern Territory, about what it would look like for people in social housing and rental properties. What are the policy barriers that need to change at that jurisdictional level? I think if in Victoria there's been a range of additional challenges, we're talking about 10,000 kilometres of transmission line right across the country, a lot of that in Victoria. So I don't think those transmission companies nor are the state and federal governments thinking about the cumulative cultural impact of what that will look like, what that footprint will look like across the landscape. Again, in Victoria, there's been a range of issues around offshore wind, that classic, proponents dividing and conquering our nations or even within families. That's happening in Victoria, but it's also happening nationally. And there's been a missed opportunity, I think, by the federal government, particularly on offshore wind, to actually do this better. And we can come back to later the First Nations Clean Energy Strategy, which is where we're trying to get the government to think about what their role, is in ensuring there's free, prior and informed consent right from the design phase, right through the project. Yeah, go on. Yep.
Is there any national policy framework or regulatory framework for renewable energy nationally?
So this is the thing, and I think, if Jonathan wants to add to this, there has been, it's really complicated, and there's a range of different policies so they've put out $20 million, I think it's billion actually, in the Rewiring the Nation. There's billions of dollars going to critical minerals, billions going to hydrogen, and they've only just announced a federal mechanism, which is the Future Made in Australia Act, to actually think about what those policy pieces look like. And up until recently, there hadn't been any particular federal mechanisms to deal with and, support the First Nations engagement. So the First Nations Clean Energy Strategy, which will be out later this year and there will be some money in the federal budget for it, is the first time in this renewable energy transition that actually there's been specific policy levers to think about how we might engage. And all of those pieces that I just mentioned, those billions of dollars going to the industry and others, there's been only one bit that's earmarked, and that's under the hydrogen, and they gave $2 billion to the hydrogen industry and $2 million for traditional owner engagement. So, we're in this moment in time where if we don't actually do the work both federally and at each jurisdiction to change those policy barriers, but also ensure that we're in all of those separate policy pieces, but also that we're part of the First Nations Clean Energy Strategy. Does that answer that? Yep.
Yes, thank you. Thank you. In terms of the funding of large projects, does the CEFC fund many of them?
So they've got a role to kind of increase finance going into the clean energy sector. They are also meant to think about, new technologies. They'll receive some of the money, the 20 billion that's from the Rewiring the Nation, but they don't have a specific mandate around First Nations. There's a little bit in there that's about kind of guidelines, and they've got a screening process. But at the moment, there's no federal fund or even jurisdictional fund that says we will support First Nations communities to set up microgrids, to be part of the massive decarbonisation process. Some of the big companies in WA are saying $6 billion worth of decarbonisation. So while the CEFC and ARENA, they've got the microgrid, First Nations microgrid piece, it's, 100 million. There's not a significant fund yet that actually just focuses on First Nations. And I think it's probably just useful, I'll just do this briefly, and then I don't know if Jonathan wants to add some things, but in Canada, which, 20 years worth of work, they talked about 3 phases. And the first phase was about kind of local projects. So that's local First Nations owned projects, but it was about being backed by legal recognition of rights and treaties. And so that's what they did 20 years ago. That meant that first phase of renewables actually was really First Nations driven. The second phase was, and I think this is also significant for us, it's where people actually really, and this is our mob, realised that there was economic development opportunity, and I think of the scale that Jason and Sonja and Nick have talked about. So people kind of had that shift. And then there was policy reform that then incentivised proponents doing the right things, which is First Nations jobs and benefits and procurement. And then the third phase, which is now seeing First Nations in Canada own 20% of the electricity generating infrastructure, which is significant, including transmission lines being jointly run by mob. That bit's then consolidated large-scale projects, and they've got 200 First Nations owned, and in Australia we've got less than 10, and none of those are actually fully built yet. So you can see that we're a really long way behind.
And so do we take it that you would characterise Australia as being at that first stage, or perhaps not even?
Perhaps not even. But I think that I think we have changed the story, and there's a recognition that if we change policy and we resource properly, that actually this revolution can be done differently. I also think the government federally, and I think we're now seeing a different jurisdictions realise it can't be done without us. Can't be done without our cultural knowledge, our leadership, and also our traditional owner groups being really resourced. That's a change. So I think while we are still at that first phase, I think this is a really critical moment to make sure we back it in.
Thank you. Would any of the other panelists like to make any comment on that which we've just heard from Karina? No? No? Any questions from the commissioners?
Karina, I'd be interested to know if there are any Indigenous involved wind farm operations that you know of?
In Australia?
Yeah.
Not yet. That are First Nations owned and run? No.
Or even involvement like some sort of agreement about a revenue stream or some payment for use of land?
I'm not sure if Jonathan wants to take that, but my understanding is there are some projects nationally that are at the agreement stage, the Indigenous land use agreement stage. The Sun Cable project, which is primarily solar, is now looking at a wind development as well, and that land use agreement's actually looking quite good. But again, the commercial in confidence means we haven't seen all the agreements that are underway. But there is, I think, I don't know whether Jonathan wants to talk about some of the other Victorian examples where people actually feel like they are negotiating something quite good.
Yeah, so I'm happy.
If that's of any use, we've finalised commercial terms for a wind farm, if that's useful.
Thank you, Mr. Llewellyn-Jones. Nick, Jonathan?
Yeah, sure. I mean, there's a range of, negotiations underway at the moment. I'm actually reflecting on a conversation I had with an elder from Gunditj Mara country, and she talked about 25 years of engagement with wind farms, and the best they got was, I think, they funded a women's barbecue at one point. And so there's that kind of legacy that we've got to overcome in renewables, that, we've got this new industry that's come along and it thinks it's doing the right thing, but actually there's a lot of legacy issues to overcome, and people haven't been compensated for infrastructure that's been on the country or received promises of jobs and businesses in the past. And so why should it be any different right now, I think, is the sense that we're getting.
So taking on Commissioner North's question, do I understand from your response, Karina, that there might be some Indigenous land use agreements where there are some payments made to First Nations or traditional owner groups, but are you aware of any in which First Nations have an equity position in relation to wind farms?
There's one that's in relation to hydrogen, and again, I want to be careful about what we disclose in terms of commercial and confidence, but we understand there's some equity in one of those projects. But I think one of the things about equity, and there's some great examples, from South Africa, about 12%, and Canada have got different, 10% right through to British Columbia, who's looking at 25% for hydrogen projects. I think it's about when the equity comes in and making sure we're not setting traditional owners up to have equity in the risk of the project as well. So there is some detail in there to think about, but there are some examples from WA and South Australia, WA border, where there's equity in the project.
Thank you. Did you want to add anything, Rebecca?
I just thought I could add there, Tony, there are agreements that we are aware of at GIRA where there is equity within the Illawarra. Northern Queensland is one that we can speak to. And secondly, where we're piloting some work with traditional owner and developers prior to a RES actually being announced, which is sort of progressing since then, it is very much on the table as an upfront first 3 negotiating points as we speak.
Thank you. I might just turn now to Paul. Can you just explain for the commissioners the Federation's role in respect of representation of traditional owners as regards the renewables industry?
Well, our involvement dates back to 2019, where we advocated to the state government for a renewable energy roadmap that didn't eventuate, which recognised the impact of renewable energy projects on country and the requirement for traditional owners to be able to have a say in the planning process, and ensuring that that's underpinned by UNDRIP and free, prior and informed consent to ensure that there's ability for traditional owners to not consent to work when there's significant impacts on country, and through a recognition of the opportunities for traditional owners to, I guess, and for government to right the wrongs of the past of the energy sector and the opportunities that have been missed by traditional owners to be able to benefit from those activities that are extracting resources from countries. So we've been advocating since then, and there hasn't been a joined up approach for traditional owners supported by government to undertake that and ensure that that process is underpinned by those principles. And we've continued to advocate, to make submissions, to meet with government over that time, without any support and resources to be able to do that, because we recognise the importance of this transition and the need for traditional owners to be able to be part of that transition in a culturally appropriate and again underpinned by UNDRIP, and we've been doing that since then, and even to the extent that only the most recent meeting of traditional owners coming together earlier this year in February, supported by the Commonwealth, not by the state, to be able for traditional owners to be able to come together and look at the issues, as well as share those experiences and to be able to learn from that and plan their way forward.
This is Victorian traditional owners or nationally?
Or in traditional owners.
And so the Commonwealth funded a meeting of Victorian traditional owners to come together to discuss matters of the renewable industry?
That's correct.
And so is the Federation able to make a further submission to the Commission about the proceeds of that meeting and what it would like to see happen in Victoria?
Yes, we are prepared to do that. We've prepared many materials in partnership with the Clean Energy Network and the ILSC and First Nations Legal and Research Services to be able to support traditional owners in their decision making and to build their capacity. And we'll certainly be able to provide those documents to the Commission.
Thank you. Now, we heard from Jason and Sonja and Nick in relation to the Barngarla developments. They are all premised upon their native title. It's a different situation in Victoria, isn't it, in terms of using native title as the point from which to leverage agreements?
That's correct. Victoria's been heavily impacted by colonisation and the extinguishment of native title. 60% of land in Victoria is freehold. A further 20% of Crown land has formerly been freehold. Therefore, native title has been extinguished, and the remaining 20% has strict management regimes that make it inappropriate for renewable developments. And I think those areas that have been acquired through native title and TOSA are very few and far between, and therefore not appropriate for any opportunities as well.
Well, you can take it from me that the Commission has heard about the very small areas of freehold land made available under the Traditional Owners Settlement Act. So in what you're saying is that there's, in terms of land ownership or possession of rights in respect of land in Victoria, it's very, very difficult for traditional owners to have a foundation from which to commence negotiations. Is that correct?
Well, that's correct. As per my evidence to the Commission recently, the procedural rights afforded through native title and TOSA don't typically apply in this case due to that low number of land that's been acquired through those processes.
Most of the projects are done on private lands.
That's correct.
And the proponents choose not to speak to traditional owners?
Well, they're not required to speak to traditional owners. The government has recognised the need to be able to for traditional owners to be involved, and has started to establish processes such as benefit sharing through the Victorian Transmission Investment Framework that will see benefits flow to traditional owners. However, we're concerned that might disincentivise any direct negotiations with traditional owners, and also have the view that process hasn't been self-determining. It hasn't been designed by traditional owners, and that needs to ensure the final details are not there yet. So it's hard for us to fully comment on that until those processes are revealed.
Can you just explain for the commissioners your understanding of what the Transitional Investment Fund is intended to do, though?
The investment fund is there to recognise the impacts of the transmission on country to traditional owners, to landholders, to communities and adjacent landholders, to provide some sort of compensation to those affected communities and individuals.
Should the development of this renewables industry be an opportunity that government can see can contribute significantly to First Nations, first traditional owner economic independence?
I think with the right settings and with the requirement through planning and procurement and the like that underpinned by legislation, then those negotiations can be had, similar to the Barngarla situation and experience, so that traditional owners can negotiate outcomes according to their own needs and priorities, and therefore establish strong an economic base of those agreements to be able to, create those economic prosperity as they all seek.
To your knowledge, has there been any commitment to developing those frameworks or that legislative structure for participation in the renewables industry?
I'm not sure at this stage. I can.
Would anybody else like to answer that question, or perhaps it's too early to say?
I can jump in and have a stab. Look, I think the energy system as a general comment is obviously enormous, and it touches all of us in different ways, from how we wake up in the morning and whether our house is cool or hot and comfortable, to whether our business operates, to whether we can run the economy. And it obviously is an enormous vector for change and has the ability to do things differently. Each state and territory is doing things slightly differently. And then nationally, we've got the Commonwealth coordinating the whole system with its levers of political power and funding. As a general statement, I think there's a long way to go, and we haven't got the policy settings right. When it comes to Victoria, there are initiatives here that could be done far better. For example, when it comes to the release of areas in what are called renewable energy zones, which are essentially areas of high prospectivity for wind or solar, that are designed on engineers' desktops, you'd say, in distant areas. There's little input from those into those areas by local communities, by traditional owners. And so, of course, when people find out about them, they're surprised to start with. And then the way that renewable energy companies are allowed to develop projects within them, government sets the rules essentially for those. In New South Wales, for example, they have incorporated for a number of years Aboriginal outcomes into those. So there's percentage targets for employment and business involvement, not for ownership, which would say at the network is a detraction, but we haven't done that in Victoria, and other jurisdictions similarly haven't taken those steps. So there's a range of, you'd say, fairly vanilla policy tools that governments could take to really incentivise better outcomes that are quite simple, that could be incorporated, that haven't been taken yet.
So if I understand something you said a few moments ago, there's no input by traditional owners into the development of, or the decisions around declaring REZs or renewable energy zones. Is that correct?
Correct.
And obviously, it can't be said then that the declaration of those renewable energy zones are consistent with the principles of free, prior and informed consent or any self-determination.
Correct.
I might add that through those renewable energy zones that the VTF includes a strategic land use assessment process, which will identify areas within those renewable energy zones that can include traditional owners to be able to inform those processes.
So are you saying that there are works in the planning to try and remediate that situation?
My understanding is that there is an opportunity for traditional owners through those strategic land use assessments to inform the final results of where those REZs are ultimately lie.
Thank you. Any comments on those matters from any of the other panelists?
If I could, just quickly, given I've negotiated a lot of renewable energy agreements for Barngarla and in other contexts as well, I would say, for what it's worth, that there is no current legal regime which would assist effective, robust negotiations for First Nation groups outside of native title in Australia. Native title is hard enough, really, to get proper economic stakes in projects. I can say, having negotiated over a dozen of these agreements for $500 million projects now at either MOU phase or final UA phase, I would struggle to find any regulatory regime set out in Australia which would properly enable a proper stake by First Nations groups for any of these projects outside the native title context.
Thank you, Nick. Any questions from the commissioners for the panelists before I move on?
Just a comment, really. I mean, we heard from the Minister this morning telling us that there was hope for future in this area. And I have to say what I've heard now dims those hopes quite a bit.
Can I just ask Paul, the Minister spoke about community benefit funds in the future, potentially in relation to, offshore renewable wind projects. Do you know about them or have any information about progress or potential outcomes?
I'm not aware of them. I would think that knowing that offshore wind occurs in Commonwealth jurisdiction, then there may be something that's being arranged, but it's not to my knowledge that there in regards to a community benefits program in regards to offshore wind or on terrestrial on land as well.
You mentioned the benefit sharing. So that's in the future again?
It's being designed at this stage, so the detail's not there as far as the benefit sharing, but it has identified the four main areas for benefit sharing from landholders, adjacent landholders, communities and traditional owners is identified as a separate part of that benefit sharing arrangement.
But it's not in place yet?
Not in place yet. The detail hasn't been revealed for us to comment on.
Who's written the detail?
Vic Rid, I think it is.
Thank you. Sorry.
Thank you. I just propose now to turn to Rebecca Halliday. Can you just describe for the commissioners your experience or the experience of GIRA consulting in the area of renewables development in Victoria in particular, but elsewhere?
Sure. Thank you. So I should start with a little bit of context. So I'm a former Commonwealth Government senior exec for a period of time, primarily in Indigenous cultural heritage protection and administering the Aboriginal and Torres Strait Islander Heritage Protection Act. I've recently been appointed to the EPBC Indigenous Advisory Committee, and I'm proudly associated with the First Nations Clean Energy Network since 2003. I've been fortunate enough to be putting together some rights-based principles cooperative agreement making in the Pilbara since 2017. And that's the closest that I'm seeing to any other kind of structures which are being determined by traditional owners. GIRA works with currently with 27 traditional owner groups and more than 12 different renewable energy companies who have anywhere between 1 and 10 projects on the go as we speak. We work closely at the coalface of renewable energy transformation and its cross-sector capability. Lots of hands-on support, to be honest. First Peoples culture and heritage, supporting agreement making, particularly where native title does not exist, and very much looking to support community, industry and developers find both the perspectives, values and to bring the voices of Australia's First Peoples to the forefront. The structures in the environment aren't yet culturally appropriate or inclusive, and nor do we see that they're sustainable. So we're working really hard to create and build values-based partnerships for the benefit of country people and their communities.
Thank you. Now we've had some discussion with Paul Paton around the renewable energy zones. Do you have a view as to whether there's a fundamental problem with the location of those zones?
I do believe that there is a fundamental flaw in the way in which their renewable energy zones are planned and then proposed and then declared. We consider that there's a role of government, both local, state and federal, in the development of infrastructure and industry on country, and that there's two critical leverage points that should be the points of attention. Both the regulatory, land management, environmental, heritage protection, community development, and of course assertion of their rights and their interests. Secondly, contractual procurement, incentivisation of public good outcomes, government as the client. We would argue that government has not yet fully explored how these powerful levers could be used to work in the service of genuine self-determination for Australia's First Peoples.
And so you're aware of the Indigenous procurement policy that has been in place for a number of years. Is that something that might be brought to effect in the renewables industry?
Absolutely. My business partner has been supporting both the IPP development and reform work, and also at the state level in New South Wales in the Aboriginal procurement policy, where it has at least some teeth, where if developers don't meet the targets or the commitments that they agree to, that there is a financial penalty to that. I'd like to see that enacted on a federal level, but I also see that it's a holistic solution, that looking at engaging and partnering with First Peoples, both in equity and ownership of renewable energy, goes far beyond the infrastructure and the contractual arrangements. It's around what are their strategic goals, what are the opportunities both at education, employment and procurement, supply chain, that go beyond the life of a renewable energy construction phase into operations and maintenance, rehabilitation and repatriation. And in some cases, we're working really hard to look at divestment of freehold lands back to traditional owners. So yes, it certainly can feature, but it's one of what should be a holistic approach.
And is timing of First Peoples' involvement in renewable projects an issue? We heard from the Barngarla people about their ability to manage the process by being able to call for expressions of interest or tenders. Is the ability to be involved early or control the process something that needs to be better catered for in the frameworks?
Definitely. Ideally, government would engage in a collaborative design and participatory decision-making process with First Peoples before pre-feasibility, pre-proposal stages of a renewable energy zone, to first and foremost identify and map where needed, and understand the significance of these important cultural landscapes, and seek to find mutually suitable outcomes to do that mapping together, to take into account animal species, sacred sites, both tangible and intangible cultural values, and to actually think about and offer the opportunity for First Peoples to be the first at the table for equity, ownership and development.
Is the failure to provide for that opportunity really a failure of free, prior informed consent?
Definitely. It's not only understood by government or developers, it's not fully understood, I should say, by government or developers, in our opinion, what free, prior informed consent actually means, that it's not more than a once-off process, and how that fits into the entirety of the principles of UNDRIP. And we've witnessed some really counterproductive behaviours and actions despite traditional owners' best endeavours to communicate and engage in a meaningful way in Victoria. And we've seen that really hamper where we've got developers who are working to support and have, in some cases, written to both state and federal government to declare their support for traditional owners' rights and assertions.
Is there a risk that in Victoria and elsewhere, without making provision for traditional owners to be at the table, that we will see a repeat of the mistakes of the mining sector, where groups are only approached with a fait accompli once the everybody else's interests have been ticked off? Is there that sort of risk in Victoria?
We do believe so. Look, it should be said, in some cases, traditional owners and their representative bodies are rapidly developing capability and capacity and know their rights. They assert their rights and both under Australian and international law. But the challenge is the poor behaviours and decisions of government and the industry to support where that is working well. What we are seeing, though, is that in some cases there is a need for First Nations communities actually have a greater opportunity to information, to education and communication, and an equal understanding of the rules of the game at that point in time. The current behaviours in the sector are often confusing because they're not cohesive from state to state or region to region or even res to res, and within some times. They're not replicable, so they might understand one particular process and then all of a sudden there's a different set of rules being played out. And at the project level, there's a real level of not knowing what their roles and their responsibilities are. Today's example that's being talked to is a really fantastic example, but unfortunately there's not enough of those.
Can I ask the other panellists if they wanted to comment on any of Rebecca's observations just at that point? No?
I
yeah. Do you, I suppose because you're differing over in Victoria, do you don't have heritage rights as well?
Yes, Jason, there is heritage rights here.
Yeah. Well, it's like you need to be involved from the start. So, like, like going out, there's some places where they want to put a wind farm or a solar farm, and fair enough, but then there's some places they just can't build it, whether it's, that tangible and intangible connection to the country, those storylines, those songlines, those burial sites and sites of significance. So First Nations people need to be involved from the start so they can protect and preserve those, preserve those areas. And I fully agree with what, the process, what you spoke about, this needs to be involved from the start. It's about unlocking land, just different with that native title, but unlocking land and giving, land back to the traditional owners as a way of moving forward to make real term benefits for those First Nations people to come into the next, to take that next step. There needs to be something, along that. It's about working with those First Nations people to transition to this new era.
Yes, that I think leads into the next topic, which is, there doesn't seem to be a lot of general understanding in the community about the renewables industry, and it has a significant amount of its own language, if I can put it that way. Is there any education or communications work that needs to be done within the First Nations communities to be able to participate in these processes or understand the effects of these processes better?
Sorry, just before we go forward, I just wanted to, can people hear me?
Yes.
Yeah, I just wanted to speak to what Rebecca was talking about, the free, prior and informed consent. There has been an instance with Barngarla where we had negotiations, we had tenders, we put out for tenders, we had quotes come in, and then the government got involved and tried, that was before my time as the chairperson, but then the government got involved and then tried to determine or tell us who we were actually going to deal with, even though we'd already gone through the tender process. So even when you're there at the start, there are instances where the government come along and try to determine who you're actually going to be negotiating with. And I don't know the reasons for those. Maybe there's some backdoor dealings going on with pretty big Australian companies. But yeah, we'd gone through the whole tender process, and then we were told, I mean, we came out in the end really well because we got the land back. But yeah, so even when you're there at the start.
Thank you.
And I agree, like it was Sonja, it's that competitive bid process you can go through, but the government still tries to step in and try to, it's seen as in South Australia, it's different. It's what they call the Gilman. It's seen as a conflict of interest, where it's not a conflict of interest for us. It's a conflict of interest for the government where they changed hands. But it would be a conflict of interest for us if we went through that process again, where the government tried to force us, because logically we will still pick the first company, but government seems to still interfere through that whole process. It's about staying true to yourself as a community and as a board and standing up to the government. Well, if you want to fix this, well, easy, give us the land. But that's in our case having native title. So that's where we had that process and basically become the landlord of that property.
Maybe just to put some context on that very quickly, I think the answer is that early engagement can sometimes be a shadow process for the government to take control of decision-making if there is a native title decision-making context which exists. Now, that's obviously the case with Barngarla, may not be in Victoria. Barngarla have had situations where the government have come in and said, we want to try and get you involved early. It's become very clearly that what they're trying to do is actually take control of who the Barngarla can deal with and sidestep that process. So there can be a nuance to early engagement. Sometimes early engagement can be about control. It can also be very healthy, not against it. It's just the devil's in the detail.
Thank you, Nick and Sonja and Jason. I just want to deal quickly with the question of whether there is any information or capacity sort of development needs within the community to understand what the renewables industry is about.
Can I jump in, Tony?
Yes, please.
So I think one of the things that the network advocated for really early on was almost like these SWAT teams to go out to where the hotspots were and talk to people about country planning and really resource people. So that was one of the things we've talked about, the government doing that resourcing. But the other thing that we've done as a network is produce a number of guides and toolkits. And, obviously, given the jurisdictional and land tenure arrangements, the negotiation guide that we did, applies differently to different people, but some basic principles, resources, access to experts. The other toolkit we did was a community energy kind of how-to guide. So that's sort of for people who are wanting to do their own community energy projects. And then the other one was best practice principles targeting industry. And then they went away, the Clean Energy Council, and worked with KPMG and actually did what does it take to implement those best practice principles. So there are a number of resources around. We also ran a program and brought the Canadians over for 5 days to do power makers, but that was, really to support people in, everything from community energy planning, business management, energy systems, how to access finance. But, I think to acknowledge that work is great, but there is so much more that needs to be done. And then what's the role of government and industry in all of that resourcing and making sure people understand a very complicated system?
Commissioners, do you have any questions at this point? No. Okay.
I have an observation, though, that every time the government needs to keep pushing back or putting their hand in where they're not really required to. So I've just noticed that on everyone we're speaking, the government keep coming back saying, hang on, what about this? Or we'll do it this way, rather than the Victorian government has a self-determination strategy, which obviously isn't really working. But I've noticed that everybody has spoken about that, which isn't helpful.
Thank you, Commissioner. The other topic I wanted to touch on this afternoon with the panel is the other benefits that are available to communities besides simply a share in the project or compensation. We know from the international experience that communities can benefit significantly from community scale solar and other side, I suppose, or less away from the large end of the renewables industry. Is there any comments that the panel might have about the other benefits that community might get from the First Nations communities might get from the renewable sector?
I might, while I've got the floor, Tony, I might just quickly cover a few of the smaller end things that we're witnessing and seeing as positive impact for First Peoples communities. Particularly things like where studies and both technical and non-technical are being commissioned for renewable energy projects, zones and the like. We're often seeing that where they're shared freely as part of these partnerships between proponents and communities and their representative organisations, that they're actually using those to align their strategic goals. They're informing them around various elements and changes in country. And we're even seeing where artificial intelligence and traditional knowledges are being brought together to actually map and improve country, and in some cases provide rehab and healing country activities occurring both with ranger programs and outside of that. So there's a number of different ways in which knowledge, when shared, is actually providing benefit. And secondly, we're also seeing opportunities where there is that early engagement and there is alignment to the broader aspirations and needs of traditional owners and their communities, where things like river ranger programs and other, ecological works, improving water and riparian zones, working with not only the local, the state, and then tapping into federal grants and funding is providing longitudinal economic benefits through things like fee for service. They've got ranger programs being established and becoming self-sustainable. There's a number of different smaller end things that are really more beneficial outside of the project itself.
Thank you. And those smaller end things are often the things that the community can see and feel and be involved in. Are there any observations that any of the other panelists might make in that regard? Any other comments?
I think probably just add, I agree with all of that, but, this setting up sort of, First Nations businesses and ensuring that the job opportunities are really genuinely there. We need to be doing the work now. Like some of the larger scale export projects aren't thinking about the workforce that's going to be required to build. We're talking about 500,000 jobs here. So I think that local training, capacity building, but also actually making sure there's, long-term, safe, permanent, reliable jobs. Really, there's a lot of work those large-scale businesses aren't really thinking about. And probably just the other thing is around this sort of access to clean, affordable power. We're also seeing some of the large projects at this point propose to export power past communities that need it the most, and they're not including those in the negotiations, that actually those small towns and communities should have power themselves. So I think there's still a bit of work to do here in changing the story that, yes, there's money and revenue sharing and equity, although I don't think we're there yet either, but there is also this local, really building businesses, making sure there's actual jobs that aren't just one-off construction jobs. And then I think the energy access piece is still pretty critical as well.
Jonathan or Paul, was there anything you'd like to add?
Yeah, I guess, again, from a systems level, these are lessons that could be drawn on from overseas. It was in, I think, 2011 in South Africa. They developed an amazing scheme that essentially was all about black empowerment through renewables. Again, a country going through a transition, they were trying to get off coal onto renewables, and they created a scheme that really incentivised black ownership, local black outcomes, black jobs from renewables projects. And again, really simple policy tools that can be put into schemes about how government allocates funding and spends it, taxpayers' dollars, to get these sorts of outcomes. We've done a piece of work around jobs and we'll be releasing that soon. But I guess what we've found that in these renewable energy zones, the First Peoples population is typically really quite high. It's much more than 3 or 4%. And so targets should be higher than 3 or 4% if we want to get the good job outcomes. But targets aren't just one thing. It needs to be this whole systemic approach. People need to be talked to about what a career opportunity looks like. They need to be given career pathways, not just kind of trained with no outcomes. And then I guess in terms of business opportunities, I haven't seen in my time with the network, which is nearing on 2 years, any government department come up with a First Nations business support program that's specifically directed towards business opportunities and renewables. And this is where Australia's economy is heading. This is, going to be billions and billions of dollars worth of expenditure that's happening right now, and there's no support mechanism to get First Nations businesses those opportunities.
Thank you. Paul?
Not much more to add, but just building on the business, I think drawing on the expertise that sits within these large companies to identify potentially ventures that would perhaps start out as a joint venture, but with a transitioning out as the expertise grows. So those types of arrangements could be initiated as well to be able to transfer knowledge and technical knowledge into those businesses and maintain a relationship and partnership that ultimately ends in 100% business ownership by traditional owners or Aboriginal people.
Thank you. Somebody from one of the remote locations, Sonja?
Yeah. So in regards to real jobs in the renewable energy industry, we just, our common law holders and bungalow members approved an ILUA about 2 weeks ago with a company, a graphite company, who wanted a desalination plant which crossed 5 metres of our native title. Now, the whole mine is on extinguished land, but because they needed that water and it crossed our native title, they approached us and we did an ILUA with them. So within that, we've got KPIs. So Jason, you and Steve and Uncle AJ talked about KPIs many years ago. So we've got built-in KPIs that we will hold the company accountable to. There's also a position for our Indigenous Communications Officer, which we request that it's an identified bungalow position. And also because where they're actually building it, in an area that's not highly populated, there's about 100 jobs going just in that. And they are really looking to employ bungalow people. But with that comes a lot of other problems because there's not housing there and that kind of stuff. So we would need to work out how to get around that. But yeah, we're trying to hold renewable energy companies that we have negotiations with to KPIs that are built into the ILUAs. And they're accountable for achieving those goals in there. Have you got?
Oh, I think that's right.
Yeah.
And I'll jump in there first, Nick, and that's like Sonja just said, it's having those key performance indicators in there, but it's, it's about writing it into the ILUA and having a protection, let alone with the renewable energy. So it protects not just us, it protects our next generation after. So real-time employment for school-based apprenticeships. So kids that are coming through school to can get into these jobs, gearing up for it, let alone for reskilling of our community as well. So it's putting those things in there and holding the companies accountable, let alone the solar wind farm companies will be coming into all this energy projects. So we need to be a step ahead of them and make sure that we have real achievable incomes for our employment jobs for our community as well as the wider community, but looking after Barngarla primarily and getting, breaking our cycle and empowering our next generation.
The evidence overwhelmingly, at least to date, suggests that it won't happen automatically. I think that's the fundamental position. There's been research done, I think, in New South Wales, Western or University of Sydney, that local communities with renewable energy projects don't tend to have an upswing in jobs or broader community benefits through those alternative kind of economic growth kind of notions, or your kind of trickle-down economic notions. And so, I think as Sonja said and Jason said, they've tried to incorporate them into the specific contractual arrangements for the projects, which, existed in the mining industry previously as well. Whether or not it's successful, we'll have to wait and see. But the evidence definitely suggests it won't happen automatically.
Thank you.
And it's also about trying to engage our community to start up their business. You need, it's not being the old grounds person, it's people might do a civil business to do the earthworks and employ people, and might be and stuff working in there. It's about pushing the community to think about starting their own business as well, to engage to actually do all these projects within that community as well.
Thank you, Jason. Commissioners, I note the time, and it's we had set aside time till 5 p.m. this afternoon for this panel. I've completed the questions I wish to ask of the panel members. Are there any further questions from the commissioners in relation to these matters?
I just want to thank everyone, and not to take the limited questions that we've asked as kind of a lot to process in this space and new opportunities for our people, but also so I just want to thank the panel for coming forward and sharing quite a lot of detailed information about the fight, the struggle, and the resistance, but also your achievements as well, which are really important to highlight. I just want to thank you for coming forward.
Thank you, Commissioner.
All of you. Thank you.
Chair, that concludes the evidence for this afternoon. The Commission will next convene in Robinvale on Wednesday, the 24th of April, at an on-site location of which the Commission is aware, and with evidence from Mr. Brendan Kennedy, followed by evidence from the Minister, Helen Shing, in Robinvale later that morning.
Harriet Shing.
Harriet Shing.
Council.
I apologise to the Minister. Commissioners, I think it's appropriate to adjourn at this stage. Oh, sorry, there are some matters of tenders that I will deal with while I'm here, Commissioners. There is tenders in relation to the witnesses today, Monday the 22nd of April. There's the witness statement of the Minister, Lily D'Ambrosio, MP, that was tendered this morning. The First Nations Clean Energy Network Best Practice Principles for Clean Energy Projects, the GLAWAC Renewable Energy Strategy Objectives, Gunai-Kurnai Lands and Waters Aboriginal Corporation submission for offshore renewable energy infrastructure area proposal, Bass Strait of Gippsland. Document 5 is the Victorian Government's Offshore Wind Energy Implementation Statement, number 3. And then with respect to, then the document number 6 is the Australian newspaper online, Gunditj Mara Traditional Owners Slam Energy Minister Chris Bowen over offshore wind zone. Document 7 is a First Nations Clean Energy Network summary of key legislation applying to offshore renewable development areas. And then from this afternoon's panel, the presentation from the Barngarla Determination Aboriginal Corporation, and at document number 8 and document number 9 is an independent expert panel on interim emissions reduction targets for Victoria 2021 to 2030. In addition to that, Commissioners, there's a general tender list for hearing block number 6 on land injustice, week 2. That's which is the week commencing last week. There's a bundle, tender bundle, comprising 93 documents, which has been handed up to Commissioners, and I don't need to take you Commissioners through each of those documents, but I tender the documents contained in the tender bundle.
All of which will be entered into the record. Thank you.
Thank you, Commissioner.
Because it's an unusual formatting of evidence, I just would like to note that we're excused, I assume, as witnesses now.
You're just about to be. Thank you, Chair.
You are excused as we adjourn. Thank you very much again.
Thank you.
Thank you.